All right, welcome to another episode. Today we are talking about estate planning, and we have Jessica Villar. She's with Schneider Associates, which is a local law firm that has done some work for our clients before. And it's not the most exciting subject, but it's an absolutely relevant subject to talk about, which is you need to have an estate plan. And obviously, we're dealing with rental properties. You know, we're accidental landlords. We have real property. It's really important that you structure this stuff correctly. So when you pass on or if you become incapacitated, you don't leave behind a huge mess. And I can speak from personal experience with our clients. A lot of clients that are newer clients that come to us are in really tough spots, i.e. their parents passed, they have a mess on their hands, there's multiple siblings, there's multiple properties, nobody's getting along, they're trying to figure out what to do about them. And a lot of this stuff can be avoided with a little proper planning and setting up your wishes ahead of time. And that's what Jessica is going to talk to us about. She's really good at what she does. So let's bring her on the show and see what she has to say. Jessica, welcome to the show.
Thank you for having me.
Yeah, we're excited to bring you on and talk about a important topic for our listeners. But before we get too far, you're with Schneider Associates. You're an associate attorney with the firm. Why don't you just take a minute or two to introduce yourself and kind of give our listeners a quick bio on you?
Yes, definitely. So Jessica Villar, as you were saying, I am an associate attorney here, and I do primary transactional law with a focus on estate planning, administration, and corporate transactional. So a lot of my practice is dealing with estate planning and having people plan and prepare for that, which I know oddly doesn't always deal with that. It's getting your stuff in order for just being an adult. So that's a lot of ideas how, what I'm here for, kind of discuss and how that fits in here. But I am a SoCal original, so born and raised. I'm relatively new to the area though. I'm getting to fall in love with the lovely 805 area, and yeah, happy to be here.
Yeah, likewise. So this is a topic that I don't think when you think I want to be a real estate investor, that the first thing you think about is estate planning and all the stuff that goes along with that. And rightly so. If that's the first thing you thought about, you probably never would take any action to buy a rental property in the first place. However, it's extremely important. And the reason I wanted to bring you on is because I think a lot of our listeners, some of them know what a trust is, but like in our property management portfolio, I think we were talking about this earlier, only about 30% of our clients keep their properties in a trust. And the reason we know is because if the property's in a trust, we have a contract with the trust and not the individual. So it's really easy for us to know who's where and why. So our show is geared towards accidental landlords, a newer landlord that's trying to learn how to do this business correctly. So why don't you, dumb it down, if you will, in layman's terms, in non-lawyer talk, why it's important for someone to have an estate plan and kind of what that means and all that stuff. So obviously that could be a 2-hour diatribe, but we'll try to break it up and keep it digestible.
Yeah, I kind of gave you the bullet points on it. And I think you hit the nail on the head in that the last thing anyone would ever think about when they're owning property is estate planning. And the two times people think about estate plan is if somebody is a billionaire, so they have a trust, because that's the only people who we tend to think should have a trust. Or if you're really, really old and you're end of the year and you want to get your stuff in order for when you pass. And in California, unfortunately, that is not the case. So in California, we have a probate process, which in essence, it controls what happens to your assets when you pass. Now, all you have to own when you pass away in order to have to go to probate, today it's $184,500 to your name. That's all you have to have. So I think we all know that in this great state of ours, there's no real property in any county that you're going to own for $184,500. And if you do, I would like you to reach out to me so you can let me know what county that is, because I'd be very interested. Which is why we always say if you have any property at all, you have to have a trust. And the reason why the trust is important is because it avoids probate. And the reason why probate, you want to avoid that, is in California, it's a very long and very expensive and required process. And you also don't have any control over it, right? It's like So the state of California dictates what's going to happen to your property if you go through the probate process and you don't have certain things in place.
Let's talk about what that looks like. Like, let's say, somebody dies, they have over that, they have a couple $100,000 in assets and they didn't plan for any of this. Now they're in probate. What does that look like for their family? And
so what happens is somebody has to step up. If you don't have a will, if you have a will, what a will does, and this is also the misconception, people think, oh, I'll draft a will. And anybody who goes to Staples or can Google last will and testament thinks they can learn how to draft a will. And they try to do that. A will does not avoid probate. All a will does, if it's done correctly, is it tells the court, this is what I want my wishes to be. So if you don't have that, what happens is somebody has to go to court. They have to petition to be an administrator. They have to get the court's permission to be able to act on your estate's behalf. Then now they have to go through, they have to comb through all of your belongings and figure out all the assets you own. They have to get in touch with everybody. Same thing with the property. They have to get that in order to figure out, okay, is there a mortgage on there? Is there any liens? You got to make sure you're still making payments. And then they have to petition the court. And then the court decides who's going to get what. And they decide who gets what in accordance with the law. The law basically has a default will for everybody, for every resident of California. And that means that if you're married and your spouse is going to get a certain percentage, if you have children, they're going to get a certain percentage. If you have children that you may not have known about or were not part of your life, that does not matter. They still get a certain percentage. If you have individuals that you raised and loved and you were your children, but they legally weren't, they're not your child for purposes, and the court can actually not end up giving them anything, even though it was your intent to take care of them. Or if you just, if you have family members that maybe you didn't know about or weren't close with, but you're next of kin, that's who's going to get your assets. And so that part kind of sucks in of itself, right? To make things worse, it takes the court sometimes a year just to figure that out, just to tell you what's going to happen to this property. And in addition to that, you have to pay, by law, a certain percentage of your estate is going to go to the court and it's going to go to your attorney fees. We don't control that. That's by statute. So that's why I say it's expensive, because even if the attorney doesn't do anything, they're still going to get a certain percentage.
How long does that? So let's say they pass away, that you got to go through probate. What happens for the year that you're messing around with the courts? Like, I assume everything is frozen. You can't really do anything until that happens, or?
Correct. Right. So there's very little you can do. Everything's frozen. And basically you're just kind of waiting around for the court to issue final orders. There's stuff you can do in between, but you're very limited. You have to get the court's permission to do anything really, unless they grant it ahead of time. And sometimes that's difficult because if somebody didn't have their affairs in order, you don't know what you have to do until you start digging in. Until you find something else and got to go back.
What are we typically looking at from a cost perspective? Like, what does the court allow for court fees and their fees, and like how much of your estate are they taking to do all this for you?
It's a percentage. There's an actual schedule. If you go online, I couldn't tell you off the top of my head because it's a sliding scale. The larger your estate, the different the percentages are, and then
Gotcha.
it keeps on rising. And then there's like a formula. And we have we don't set that. So I've seen probate attorneys that work endlessly, and their fees are the same as if all they did was show up to one hearing.
It's in essence a backdoor tax on your estate that you don't have any way of not paying, right?
Correct.
Yeah.
Pay the court, and you're going to pay. And I mean, you can attempt to try to do it without an attorney, but that's never a good idea.
Yeah.
Because it's even most attorneys, you have to be a probate attorney to do probate usually. It's a very, very complicated process. Unfortunately, they did not make it so the layman can figure it out.
Yeah, that sounds about right. So probate on average lasts how long? A couple of years, or?
It'll be, so if your estate is very simple, you don't have a whole lot of assets, you don't have a whole lot of beneficiaries, maybe you're married, you have 1 or 2 kids, you're aware of them, they all get along, no one's fighting over everything. If you're lucky, I would say you get done with it in about 13, 14 months.
Oh, wow. And if you're unlucky, years?
It's years, yeah.
Yeah, so personal experience here, my grandfather passed away on my mom's side, and the family immediately started fighting over what was left, and it wasn't much. But I would get all the notifications because I was a grandchild, and this was a large family. There was 10 brothers and sisters, so they would send every piece of documentation out to every single, I assume, grandchildren, and obviously the kids. And I remember just looking at the list of people who got everything, and it was crazy. It was like 30 some people. It could be some stupid little notification, and it was going out to everybody. And which brings up a good point. That family immediately was battling over the assets, which in my experience working with our clients is not uncommon. Like, can you speak to that? Like, does that happen? Do you see that happen ever?
That happens more times than I think people care to admit. And it's funny. The partner here who helps a lot with estate planning, I think says best. When somebody passes away, it doesn't matter how old you are. When somebody passes away, their children revert back to how they were when they were 12. So whatever their disposition was when they were 12, that is exactly how they act. And what I will say from my personal experience in dealing with this in administration, 9 times out of 10, and this is the thing that shocked me most going through all this, it's the people you least expect, right? So, a lot of times people think, oh yeah, my child's very responsible. They have a career. They have a lot of money. They don't need a whole lot from me. And so they're never worried about those kids. And then they may have one kid who's a little bit lost or maybe struggles with substance abuse. And there's the ones that they're going to cause trouble. They're going to be problematic. Usually it's the ones that have it together that come in and they start fighting over every nickel and dime. And the ones that don't, they could care less. They're like, I want my father back. I want my mother back. And that's not always the case. But that, I'll be honest, that's what I've learned is don't ever expect anything because it's always what you don't expect that's going to happen. So you got to plan and prepare for everything.
Yeah. So the better move is you prevent all that, and that's done through an estate plan. So why don't you pick that back up? We went on a little side tangent after probate, but
yeah.
How do you prevent probate? Prevent the fight? I don't know that you can ever prevent the fighting, but you can prevent maybe the extent of it. But yes, speak to that.
So a trust is, in essence, think of it as a separate legal entity that's an extension of yourself. So what you would do is you would create what we call a living trust. So for your purposes, nothing changes. You actually use your same social security number. So when you file taxes, for instance, literally nothing changes for you. And what a trust does is it trifurcates interest in any kind of asset. So it takes the property, puts it into this entity, and then there is what we call a settler or a trustor, and that's the person who's giving it. So that's you to this entity, the trust. And then you're giving it and you're putting somebody legally in charge of it. You're entrusting them to take legal authority over it. That's a trustee, which 9 times out of 10 is you. You retain being a trustee, and you're doing it for the benefit of somebody else. That's the beneficiary, which while you're alive is you. That's why it's a living trust. So that's why nothing ever changes. I think a lot of times people are afraid of doing that. Something's going to change. Nothing changes for you. And then when you pass, you have ultimate beneficiaries, which means this is where the property goes. And that could be your children. It could be your spouse. It could be a nonprofit. It could be, your next door neighbor, whoever you want. That's what you put in there. But more importantly, it avoids probate because the trust owns it and the trust doesn't die with you. So when you die, the trust still has control of the property, and it basically trusts as a contract that states, okay, this is what has to happen with the property. And that's what happens. So it does help with the fighting sometimes in the sense that it's very clear and you dictate what you want to happen to your property. And then you can do one or two things. You could have that conversation with whoever the beneficiaries are. Yeah, I'm giving so-and-so this property. This is my wishes. Or you cannot. You don't have to. It's really what you want to do. If you have that conversation, sometimes you get ahead of the fighting. Sometimes you don't. But also what you can put in a trust is you can put a no contest provision, which basically says if you contest this, basically the trust is going to treat you like you died before me and you're not going to get anything.
Oh, I didn't know that. I didn't know that was a thing. So yeah. How does that explain? And how does that work? Does that hold up? Like that's legal? You can do that?
Yes. So what it is, so for instance, let's say you got 2 kids, Johnny and Ashley. Johnny gets The real property in Ventura actually is going to get whatever's in the bank account at Bank of America. Right now, there's a balance of $500,000 in there, but there's no contest provision in there. And they decide, you know what? No, I want a piece of that house. She says, I want a piece of the house. Not for that. I'm just getting the money. The money can be spent. That house is going to raise in value or has sentimental value. Whatever reason, there's always a reason why somebody wants to contest something. Well, if Ashley does that and she didn't have a valid reason, meaning she doesn't think that the trust was made under fraud or distress, she loses the $500,000. It says that if you contest this, you will be treated as if you had predeceased me and you left no living issue, meaning Ashley's kids don't get anything. Like, she just gets cut out.
How often do you see that?
So the no contest provision is actually pretty much a default provision that we always put in there.
Oh.
But the thing with that is it's only as effective as it is good. Meaning, if you already cut out a kid, or if you leave a kid $10,000, we have nothing to lose, right? So that's the other thing kind of got to keep in mind, is that if you're going to put that in there, you got to give them a carrot on the stick. They got to have something that they can lose, so they don't do that. But that's one of the ways to also avoid fighting.
Gotcha. So avoiding probate obviously is maybe the number one reason to put something in a trust. Are there any tax benefits to putting stuff in a trust?
There's no
when you pass on.
So there's no tax benefits in of itself, right? So a lot of times I think people think a living trust when you're alive is a tax shelter. It's not. There are certain trusts that can act, you do have for tax benefits. A living trust is not one of them. And you always, unless there's a specific reason why you want it in a living trust, because you want to retain control over that asset. Excuse me. Now, when you pass away, so you don't go through probate. So when you don't go through probate, there really is no creditors that can come and make claims on your estate. Now, that's not to say that there's not other little smaller avenues around that, but that's one of a good ways. Same thing with like Medi-Cal and all of that. So that helps on assets there. And then if it's in a trust and you think that taxes are going to be an issue when you die, you can start to kind of prepare ahead of time for that. So you can either get stuff out of your estate, so when you pass away, it's not an issue, or you can actually have the trust what's called bifurcate, like if you're married, and that also helps relieve some of the tax pressures that happens when you pass. All that being said, right now the estate tax limit is a little over $12 million a person. So if you're married, you would have to have died with owing over $25 million. If you're single, a little over $12 million. Now that amount's set to change in 2025, since that's December 31st, 2025.
Go down or up?
It's going to go down. So it will. Right now, we're anticipating it's going to be between $5 and $6 million when you count inflation. If they don't do anything, Congress would have to absolutely do nothing. We don't know if they're going to do something. Honestly, I think it's a 50-50 call. Congress is going to let it actually go from $12 million all the way down to $6 million. So right now, that's not really an issue for a whole lot of people. If you're lucky enough for that to be an issue, we can definitely, it helps us plan and prepare for that.
Gotcha. So what do you see as the biggest barriers to people? I think that people probably understand, okay, this is probably a good idea, I should do this. What's the biggest barrier to people actually pulling the trigger and doing it?
The two biggest things that I've noticed is one, having that conversation, having that uncomfortable conversation of what you want to happen when you pass or how you want things to be handled now. Because we ask, when you do an estate plan, it's, for lack of a better example, it's kind of like a prenup, where it forces you to ask those questions, those what if questions, which, you're not planning for, you're not praying for, but it could happen. And that's what the trust basically plans for. It's an estate plan. It's a plan for, in case this happens, this is what we're going to do. Mm-hmm. So, I think a lot of times people don't want to have those conversations. One is they don't want to talk about their own death. Two, they don't want to have the conversation of what kid should be in charge, or if any other kid should be in charge, or if one kid should get one thing or another, get another thing. The other one is if there's kids from previous relationships. That's sometimes an awkward conversation. So I think that sometimes people realize they don't want to have those conversations. You got to have that conversation when you do estate planning. But not talking about it isn't going to make the situation go away.
Yeah. I know from personal experience when my wife and I did our estate plan, it was exhausting because you're literally talking about the worst case scenario. All these terrible things are going to happen. You're both going to die. One's going to die in front of the other one. Everyone's going to die. Where's the money go? Oh, the kids aren't going to die. And then where's the money go? Like the questions that you are being asked to answer are heavy and they are taxing. And I could see where just wanting to avoid all that, is probably relatively common. I don't think that's the right move. I think you absolutely should have those conversations, but I could definitely see that. What are there any times when it would not be appropriate to create a living trust?
Yes. So if you know for a fact you're not going to reach that, you have $184,000 right now, if that is only in liquid assets, so it's either in a bank account, it's in an investment account, it's in CDs, it's maybe in a 401k, you don't own any real property, you don't want to own any real property, then what I would advise you is, and you don't have any minor children, and you don't have any plans and never having any children, then what I would say is put it into a bank account that has a payable on death. It's a payable on death account, meaning when you die, there's a named beneficiary. And as long as the assets have some place to go, you avoid probate. So if you have all of that in order, you can still avoid probate. If you own real property, you cannot do that. Now, there's a transfer on death deed, which I think sometimes people think, I'll just do that. That is a relatively new process in California. And that in itself has a lot of problems when it comes to title insurance. If you ever try to sell, when you get property transferred to you by a TOD or a transfer on death deed, that in itself, and I'm dealing with that right now with one of my clients. He's not going to be able to sell very easily. We're having to jump through some hoops to try to get it sorted out. And so it's actually going to end up probably costing him more money than had his mom just established a trust and made him beneficiary.
So there's one, I don't think that's our listeners, right? Our listeners have property for the most part. And I don't think anybody wants to play small ball, right? Like, I'm just going to keep my estate as small as possible so I don't have to go through probate. I don't think those are the people listening to this podcast for sure. So take those examples out of it. Should everybody have a living trust?
If your listeners own real property, yes, they should have a trust. And my guess is a lot of your listeners are probably, these are investment properties, right? So this is, and they may have multiple properties. And I know in California, it's not uncommon to own an LLC. That does not get around it. So that may be sometimes people think, oh, just stick it in an LLC. LLCs are good for certain reasons. There's tax benefits, and that's a different conversation. But that LLC has to be owned. That membership has to be owned by somebody. And it, again, should still be a trust at the end of the day, because it's the same end result, right?
It's still an asset that needs to be dealt with once you pass on, regardless of what entity it's in, right?
Yeah. So I think sometimes people have that misconception too, and that's not a way around it.
Yeah, I know. Just in my own personal financial life, we have a trust, and it does get difficult if you start like refinancing properties. Sometimes you have to pull them out of the trust, and then you have to make sure you put them back in the trust, and so logistically it's a little difficult. But the flip side of that, probate and a mess for your family, like it's not a reason not to do it. I think the benefits far outweigh whatever hassle you might have to do when it comes to refinancing or moving the deeds in and out of the trust.
Yeah, it's extra paperwork. And really, sometimes if you're lucky, you'll find somebody that actually realizes you don't technically have to get it out of the trust to refinance. But for whatever reason, a lot of mortgage brokers, they require that. And you just tell them, all right, now you got to prepare two deeds, one pulling it out of the trust, and putting it back in the trust, and just kind of put it on them to do that and do the filing. You're not going to get taxed, so that's another thing. People sometimes are like, well, it's a transfer, am I going to get reassessed? No, you don't get taxed, you don't get reassessed. So your property taxes stay the same.
Yeah. So What does it look like? Let's talk logistically. Like, okay, okay, you convinced me. I need to get a trust. What kind of commitment are we talking for someone to make this happen?
So it's if you're doing it like with me and my firm, the first thing that I always do is we have a consultation, and the consultation's free. So I send you a questionnaire, and it's just kind of the basic questions. If you're married, are you single? Are you married? Do you have any children? Who would you like to be the trustees so the people that you don't be responsible legally if you're not able to do it, either because you choose not to, you get older, you just don't want to deal with it anymore, or by the time comes and you pass, who the beneficiaries are, how do you want these assets to get distributed? And then there's also other parts to the estate plan. An estate plan isn't just a trust. Actually, an estate plan, it's the trust. You still have a will, and I'll explain that, why you still have a will. You have a power of attorney, or actually a durable power of attorney, and an advanced healthcare directive. So what the will does is, like you were saying, sometimes you pull stuff out of a trust, right? Or sometimes you buy things and you don't put it in the trust. Or sometimes you inherit things that you didn't realize you inherited that you own. So there's not the name of the trust. When you die, if you own anything that's outside of the trust, the will is what's called a corporate will, and you can think of it as a safety net. And what it does is it instructs the court to pour it back into the trust so that the terms of the trust will always govern. And in California, you can actually petition the court if you have the will and the documents done correctly to still avoid probate and say, look, it was always intended to be in the trust because of some mishap, whether it was refinancing, somebody didn't title it correctly, whatever, it wasn't put in there, but it was always intent. The probate court would take a look at it, say, yep, you're correct, sign an order, just put it in the trust, and you just avoid probate altogether. And then you also have a durable power of attorney, and that is basically that lets somebody deal with your affairs for anything that's not in a trust. So you don't put absolutely everything in a trust. The main things that you're going to put in a trust are IRAs and retirement accounts. Those are taxable events. So those stay in your name. And you're not going to put like life insurance policies don't get put in the trust. And then things like Social Security, right? That's obviously separate and apart. Dealing with the IRS, that's separate and apart. So a durable power of attorney allows somebody to come in and act on your behalf legally if you're not able to, or if you just don't want to deal with it. And what's also good for that is that it avoids conservatorship. So when you get older or something happens and you don't have capacity to handle your own affairs, you don't got to deal with the court process of getting a conservatorship. Durable power of attorney has control. And then the advanced healthcare directive is like a medical power of attorney, which basically states, these are what for my medical decisions, these are my wishes, and this is who has the authority to act on my behalf with dealing with my medical needs if I'm not able to. And so really, like the durable power of attorney and the advanced healthcare directive, the medical power of attorney, those aren't for when you pass, those are for right now, right? Like if something happens to you right now, you have control over who's going to be handling your affairs versus having it, the court dictate who that's going to be.
Now, that's not in probate. Like, let's say, you have a stroke and you're a vegetable, but you're not dead. Who decides what happens to you if you don't have the durable power of attorney and all that stuff?
You go to court and you have, so the most famous case that I can point to is Britney Spears, right? Now, everything, the whole Free Britney thing, because she had a conservator. They went to court and said she cannot handle her affairs. She needs a conservator. So the court looked at her. They looked at how she was acting. They said, no, she cannot handle affairs. We're going to put a conservator. And that was, her father and some other attorneys. And then she didn't have control over anything. And that's basically that's what happens if you don't have a durable power of attorney.
What if you're married? Does it automatically go to your spouse?
The court still has to make sure that it's a conservator. Just because you're married does not mean that individual has the legal authority to act on your behalf. Now, they have access to certain information. They do not have access to your medical records just because they're your spouse. Now, they may, if it's a dire situation and let's say you're in a hospital, there was an accident, they got to get permission from somebody. Yeah, they can go to your spouse usually. But in the long run, that you're going to have to get a conservatorship. That's not just automatic.
Gotcha. So there's other benefits to other than just the trust part of it. Would it be involved in being a responsible adult? Like you should do these things to make life easy for the people around you.
Also, if you have minor kids, too, I forgot to bring that up. The will, if you have minor children, the will dictates. It has an area where it states who you want your guardians of your minor children to be. Mm-hmm. So if you don't have that in place and something happens to you, then the court dictates who's going to be those guardians. It's either somebody steps up, if multiple people are stepping up, and the court's going to decide. Well, you may, have somebody in mind that you want to be the guardian, and more importantly, you may have somebody in mind who you don't ever want to be the guardian, right?
Yeah.
Like, some of us have.
That's probably more likely.
Yeah, right. Like some of us have family members that are like, look, I love you to death. I would go to hell and back for you and not think twice, but I don't want you raising my kid. Like,
yeah.
Let's.
Yeah. Yeah, so there's also an irrevocable trust and a living trust. What are the differences between the two? Because we're talking about the living trust mainly right now, right? Where you can change it, you can end it, you can modify it. What is an irrevocable trust?
So an irrevocable trust is a trust that, for all intents and purposes, cannot be revoked. It can be revoked. It cannot be changed. And that's why it's called irrevocable. And a living trust becomes irrevocable on the death of both settlers. So if you're married, and there's ways to modify this. So this isn't just a default always rule. There's always ways to modify this. But the general rule is if you're married and you and your spouse create a family trust, then while one of you is alive, you can always make changes. And the moment that the second of you dies, it becomes irrevocable. Nobody else can make changes. So whatever the trust states, that's what's happening. And then at that point, it also becomes its own separate legal entity, so it gets its own tax ID number. It files its own taxes. And so that's with a living trust. You can create an irrevocable trust now while you're alive and put certain assets in there. And people do that for tax reasons. But the reason why there has to be a very specific reason why you're doing that is because once you transfer that property into that trust, you're not getting it back. And you don't have, 9 times out of 10, you don't have control what happens to it. So basically, you're giving that away. So you have to make sure that when you're doing that, it's drafted exactly the way you want it to. You know what you want to happen to the property that's put in there. You're comfortable with never getting that property back, and understanding that you can't make any changes. So for all intents and purposes, that's not really an option for most typical regular people that are just trying to live their day,
future.
Yeah, live their lives and just have some kind of control over what's going to happen. Yeah.
Okay. So avoid probate, figure out what happens to your family, hopefully avoid some uncomfortable things by putting the trust in place. What other benefits are there for someone to consider doing this?
So the 2 other ones that I'd want to bring up, one is if you have minor children, is if you have a lot of assets, the last thing you want to do is you want to give an 18-year-old $1 million or 3 properties, because it will be spent and it will be sold and spent before their 19th birthday, 9 times out of 10. And I understand that little Johnny may be an honorable student on varsity and super responsible, but if he's 18 and he doesn't have his parents around to kind of guide him, and he has multi-million cash, good chance he's not going to have it by his 19th birthday. So it allows you to stagger distributions over time, right? So if Johnny, for instance, is a good kid and you don't have a whole lot of concern about it, then maybe you give a little bit when he turns 21 or when he graduates college, if that's something that you want to be able to control. And then you give a little bit more at 25. Then maybe you give the remainder at 30, depending on how much you have, right? I'm talking if you have a couple $1 million. Mm-hmm. And then you can also dictate that he can get money for things like paying for college, for putting it down on his first house, maybe even paying for a wedding. Definitely any medical issues, he can always tap into the money and use it. But if other than that, he'll get the income every year. He'll get paid out the income that it makes. But the principal just gets distributed at certain milestones. And that's also really important too, because if you realize that sometimes people realize they create these things when they're relatively young, and then 10 years pass and they have one kid that's doing really well and one kid that they know it's going to take a little bit longer for them to mature, so they can kind of push that out. I know that, maybe one of their children, they probably don't want to give anything till maybe they're 30. And I know nobody wants to think that, but it's a reality. It's what some parents face, and if that is your reality, that way it allows you to control that.
How do you even know these questions to ask, right? Because my next line of questioning is going to go with, why doesn't someone just go online and set one of these up on their own? Like, what are the risks associated with that? Because I'm sure they're out there, right? You could technically do it, right?
So the other thing too, before I answer your question, I want to get back to is a pot trust for minors. So if you have minors, what a lot of times we advise, or that is an option if you want to take it, is doing a pot trust. So what happens is if you die and if you and your spouse die, but your kids are young, and you say, okay, everything gets distributed evenly between my kids. While if your kids are 7, 10, and 12, then everything you have in your estate immediately gets divided into 3 and gets put into trust for each of your kids. And then the kids have to live off of that trust. They don't get the money right away, right? Either they get it at 18, or if you have it staggered at certain ages, they get it at those ages. But what they have, that third, that's all they're going to have. So let's say the 7-year-old ends up running into medical conditions when they become a teenager, and they deplete their trust before they're even 18. So when that kid turns 18, they have nothing left. But the other 2 are still going to have their full shares. So what a pot trust does, it says, we keep everything together until the youngest turns 18. Any medical needs, any educational needs, anything that has to get paid comes off the top. The way you would basically treat if you were still alive, right? You would pay whatever you needed for your kids. And then once the youngest turns 18, now we divide everything in 3, and everybody gets their share. So that's another thing. As far as what to ask, that's what the questionnaire is kind of like. That's what I like to give the questionnaire. I like to kind of get the base facts, and then I just start having the conversation, kind of like what we're doing now. Okay, I see you have 3 kids. I see in your assets that you're gonna, as of right now, you are maybe $6 million in your estate, $2 million a kid. Your kids are relatively young. Are you comfortable with giving your kids $2 million at 18? Let's be honest, this is what tends to happen. Now, at the end of the day, every kid's different. And I would always make it very clear, this is a personal decision. You know your kid, you know your situation. And at the end of the day, we're going to do whatever your wishes are, but I'm going to ask the questions that are going to make you think. And whatever you decide to do, that's what we're going to do.
And that's part of the value of hiring a professional, like an attorney who does this day in and day out. And versus if you try to do it on your own, I would imagine you're going to have a harder time arriving at those questions or not to even know what those questions are that should be asked.
Correct. So another reason why you don't do it, in fact, one of the things I just dealt with today was cleaning this up. Somebody who was at a client who was extremely intelligent, very well educated, and lived their life being able to basically handle everything themselves, and do so at a very successful degree. And they thought that along with everything else, they could create their own trust. And again, very well educated, very intelligent. And they went online and that's what they did. They did not do it right. And because they did not do it right, and they subsequently went and opened up a bank account. And they didn't open up the bank account right. It wasn't titled correctly. And then they went and they purchased property. And they didn't get put in the trust right. And so now it was just this whole web that when they finally came to us, we had to clean up. We had to take now more time, which means a lot more money to clean everything up, revoke everything, put everything back, try to fix, what was done incorrectly. And then on top of that, now we had created a new trust done correctly and get everything transferred so that it was sufficient and it actually reflected their wishes. Because the other issue is that if you do this yourself and it's not done right, when you pass away, it may even be worse off for your kids.
Yeah. They were probably lucky that they figured this out while they were alive.
Yes.
Gotcha. So you don't recommend going on rocketlawyer.com or whatever?
I never ever recommend. Anytime it's a legal document and it's a plug and play, meaning like just fill in the blank. Do not do that. If it's a legal document, it's because it holds heavy weight, which means that it is very specific to you and your situation. And there's never a reason why you should be able to just plug and play. Even like our forms, they're about 40 pages. A lot of the provisions, yes, you're going to find them in every single trust because they're important provisions to have. But I go through every single provision and I modify it based on who my client is and what their situation is.
I think our listeners definitely understand about leases because you can go to the same websites and get leases for your properties. And when we take on a property that somebody's done that with, it's just more work, more time. They're having to unwind. Same principle applies, right? Because our lease is tailored to how we manage a property, to the local laws in the city that the property's in, or the county, or what state it's in. Like it's all the same, which I think people understand. Especially, I mean, I don't know why you would, in your right mind, want to gamble your family's future with trying to figure this stuff out on your own. Because if you get it wrong, I mean, you potentially just screwed your kids over or your family or whoever else. So good point for sure. Let's talk. Obviously, the argument for doing it on your own is I guarantee you it's cheaper. It doesn't mean that you're saving money. It just means it's cheaper up front, right? It's probably going to cost you way more money in the long run. But just for the sake of our listeners, ballpark, you don't have to give us exact figures. To get one of these trusts set up, what are we looking at price wise?
Yeah,
roughly?
So it's gonna. I can definitely give you ballparks. If you're single, it usually ranges anywhere from $1,800 to $2,800, depending on the amount of assets, right? So if you have a whole lot of assets, which means we have to transfer a whole lot of properties into the trust, or if you have it's not uncommon for people to have a whole lot of business entities and they're separate entities, then that's going to always go a little bit higher. Only time if you're a single person that's going to go above 2,800 is if it's you have a whole lot of assets where it's really complicated. Or if you make it complicated, and you have every right to do this, but like I say, the distribution, it's it's going to multiple distributors, beneficiaries, multiple scenarios. If you want to get really complicated with like the kid has to go to a certain type of college, these have to be met, the more of that, then you're going to get a little bit more expensive. If you're a couple, let's say a couple with children, you're looking anywhere between $2,500 and $3,000. And that's two of everything, right? So you're going to get one trust, but you get 2 wills, you get 2 durable power of attorneys, you get 2 medical advanced healthcare directives, which is medical power of attorneys, and then all the supporting documents that go along with it.
Gotcha. So it's, it's not free by any means, but it's not like a huge commitment that's going to prevent people from doing it. If you look at it as a percentage of your total net worth, it's probably very minimal and obviously very, very worth it.
Yes, no, it's definitely like you were saying, and I was saying earlier, is that if you don't do it or you do it yourself, you're going to spend a whole lot more money trying to clean it up.
Yeah, if it's even possible. Well, let's say you screw it up, you don't set it up right, and then you die. Is it always fixable, or are there some things you can never undo?
It is. I don't want to say it's if you pass away and it's not done correctly, then we have to turn to the courts. And now the courts have to start to try to figure out what legally has to be done. And you're not around to, 1, state your wishes, or 2, to put things in order that will enable you for your wishes to be carried out. So the court can only do something. The court can also only do so much at itself. And then it becomes a game of who can outspend who. So if you have the beneficiaries, you're fighting over property, and they're fighting over distribution. Now at those points, who has the deeper pockets?
Not a spot you want to be in for sure. So the moral of the story is just do it right the first time and not worry about it.
Correct.
I know in our living trust, we've updated it several times. Like what we thought was what we wanted in the beginning changed over time. And I think that's probably pretty common to update it every once in a while, or. Yeah.
So the one thing that we always tell individuals is, so you create the trust, and once it's created, it's created. So the creation date, that is the date, that would always be the date of your trust. So you create a whole new one, you revoke this one and create a whole new one. That'll always be the date of your trust. So anything you put into the trust, that stays in. But we say usually every 5 years, or any major milestones, take a minute and read through it and make sure that it reflects what you want. So major milestones are having children, changing careers or having advancement in careers that change your income sufficiently, purchasing new properties, having grandchildren, having children or siblings that pass away. So for instance, and the reason why I say siblings, because many times you may have a sibling or a close friend or even a parent that's named as successor trustee, and then they pass, and you don't update your trust. Well, now it's your third option that's supposed to be trustee, and maybe you don't even talk to them anymore. Or maybe somebody else has come into your life that you feel would be better fit. Or maybe your children who were 12 or 15 when you created this are now 30, and they're the ones that really should be the trustees. They're the beneficiaries.
Gotcha.
So things like that. And then also anytime, like I said, major purchases, because of distribution. So, and I'm sure your listeners probably know this, but one of the not so great ideas that you can have is to own multiple real properties and say, I give all my properties to all my children in equal shares. So now you have 4 owners in one property, and 3 of those 4 owners are also married. So even though they're not legally owners, you got 7 people trying to dictate what happens to a property.
We've been there, done that. That doesn't work. And unfortunately, it's pretty common. Like, it's not uncommon that happens. We deal with it a dozen times a year, probably, which is always fun.
And so that's one of the benefits of coming in a estate planning attorney, because I ask those uncomfortable questions. I think sometimes people don't want to talk about that. They just want to say, oh, it's okay. You give it to your kids. Everyone gets deserve to be treated equally. Yes, they do. I'm not saying they shouldn't. Or the other thing that happens too, which is not uncommon, and there's nothing wrong with this, it's where you're comfortable with a parent. It maybe helps out one kid a whole lot more during their lifetime versus another, to the tunes of hundreds of thousands of dollars. So when they pass, at that point, within their right, want to kind of even things up. So the distribution is done differently. But I ask those questions of, okay, realistically, this is what happens when you have 4 people owning a property. All of them are equally responsible for now all of the upkeep, the taxes. They all have to agree if it needs a new roof, if it needs new plumbing. They all have to agree on it. If somebody wants to sell, are you going to bring in somebody new? I ask all those questions that makes them now think about it. Okay, do I want to do this? And if I don't want to do this, how can I set up my trust distribution so that it's still fair?
Yeah.
So and then we can do that.
Yeah. The more we talk about this, the more complex it gets. I think the moral of the story, I mean, if I had to boil it down to just a couple of things for our listeners, is make sure you set up a trust, do it properly, and do it sooner rather than later, because for obvious reasons that we've all talked about. Jessica, if our listeners are interested, and obviously, you're here in the same area that we are, and if they want to reach out or get a trust themselves, what's the best way for them to get in touch with you?
The best way, you can either, one or two ways, you can always email me. So I'm at Villar, J-V as in Victor, ILLAR, at rstlegal.com. Or you can give our office a call. And I'm 805-764-6370. Again, consultations are always free. So us just having that conversation and getting to know you and letting you know what this is going to entail, what's going to look like, that's free. And that at least gives you peace of mind. The biggest thing that with all my clients, whether it's estate planning or it's corporate, whatever I'm doing, my biggest thing is education. I'm never going to just do something for you. I'm going to explain to you why I'm doing it and why you need it. That way, even if you leave my office and you're no longer my client, you're still in a better position than when you came. And that's ultimate my obligation to you. So if at the very least you get an hour consultation, you decide you don't want to move forward at this time, you at least know what it is that you should be doing and why you have to do it. And so you can plan and prepare when you do want to make that decision.
Yeah, well said. I mean, in my mind, there's really very few limited, narrow reasons why somebody shouldn't do this. But the reality is, just from looking at our own portfolio, the majority of people are not doing this. So yeah. I think we're gonna share this podcast with a lot of our clients, I think, because I think it's in their best interest to make it happen. But Jessica, thank you very much. I appreciate your time and all of your expertise that you shared on this subject. And I think we'll be referencing this podcast for a while, but thanks for coming on.
Thank you for having me.